Today on LawNext, making legal research better. My guest is Itai Gurari, co-founder of the innovative legal research engine Judicata and developer of Clerk, a tool that analyzes the strengths and weaknesses of briefs. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before I get to the show, let's hear from the sponsors who generously support LawNext. And now on to my interview with Itai Gurari. Itai, welcome to LawNext.
Thank you for having me. It's very nice to be speaking with you today, Bob.
I've been looking forward to having you on the show pretty much since I started. You were on my short list of people I wanted to get to, so I'm thrilled to be able to talk to you today.
Thank you.
You are the founder of, co-founder, I guess, of Judicata, the legal research company. This isn't your first legal research company. You've got an interesting background. I mean, you started. You're a Columbia Law grad, a computer science. You have a computer science master's in computer science, I think, and you previously started a legal research company called Trace Law. Can we just go back in time a little bit before we get to Judicata and talk about why you started Trace Law and what that was?
Yeah, actually, it goes back even earlier, which is I've had a strong interest in both math and logic and rule-based systems, but also language and philosophy. I was actually a math major and a philosophy major in college, and the theoretical intersection of those fields is sort of the intersection of those fields is the theoretical foundation of computer science. And so I got into computer science that way, ended up going to computer science graduate school, was on track for a PhD and got kind of bored with the work there, heard an inspiring talk by a lawyer about some work that she was doing in terms of public interest law, and decided to leave with a master's degree to go to law school. Ended up going to Columbia. And then in Columbia, I think I got kind of caught up in the, I would say, more traditional routes that people take in terms of big law and what you do when you go to a top law school. So I ended up going to a large law firm, practicing for about a year and a half, and once again got kind
Jones
of bored.
Day. You were at Jones Day?
Yep, Jones Day, which was a good experience, but at the same time, I realized that the law is very slow-moving and can be kind of boring relative to software development. So I ended up leaving and starting a solo project called Trace Law, which was building a case law search engine back in 2008 through 2010. There was some sort of deep insights into how the law is structured, the way that precedent works, the way that the cases are linked, that was very similar to how web search works, and just realized that I could do a lot of work on making that problem better, making research faster, easier. And so that's kind of the genesis of Trace Law. Shortly after I launched that, pretty much all the competition caught up. So it was a
there wasn't that much competition in the sort of smaller legal search engine days, I guess, in 2008. Mm-hmm. What possessed you to want to start a legal research engine? I mean, West and Lexis pretty much dominated the world in those days, probably still do to a large extent. So what were you thinking in terms of wanting to start that?
It was really quite basic, actually. It was that the search engines, West and Lexis, were just not very good. They hadn't yet launched West LawNext or Lexis Advance. Google entered the space, but Google's search engine also was just not that good. And so there was, or actually Google entered after I had already launched Trace Law. But there was a lot of room for improvement in terms of the quality of search. And it's kind of hard for a lot of people to realize today how bad it was then, because the search engines are substantially better. But it was really quite simple. Just, I could do a better job.
So what happened to Trace Law?
Because it was a solo effort, I ended up running out of money. and made some connections within the field. First made contact with Ed Walters at Fastcase and folks over at Maker and Google and West, and ended up joining Google to work on Google Scholar. So it was a good learning experience on the limits of what one person can do on their own, which was a good lesson to learn for Judicata and needing to have a team and collaboration.
And Google Scholar, of course, is Google's search engine for treatises and legal cases. What was your role there? What did you work on?
I was on the software development side. I built out a few basic things like their court filters, and then a fairly sophisticated bit of functionality, which was their level of analysis measure, which probably most people haven't seen it or don't really pay attention to it. But if you click on a case to see how it's been cited, there will be a icon on the side that has 1, 2, or 3 bars, and that indicates the level of discussion of the cited case within a case. So if Planned Parenthood versus Casey is citing Roe v. Wade, you'll get an image that identifies how substantial the discussion is. And there was a lot of work to make that functionality behave properly. It's not just simply counting citations. You have to really understand the language and how the cases are being discussed. So I spent a lot of time doing the core parsing to make the understanding of the cases strong so that we could then be able to accurately identify the level of analysis.
And I noticed from reading about you, I hadn't realized this before, that you came from a family, I guess, of computer scientists. Your father was a computer scientist, a professor of computer science. Mm-hmm. Did he inspire you in some way to go into this?
No, I actually fought it for the longest time. He tried to get me to learn programming when I was young. So when I was like 13, 14, he signed into a online class for programming. I refused to do the work. So he actually did all the work for me, got me an A in the class. And later on in college tried to convince me to take programming, which I didn't want to do. It was only when I started to realize that my own interests in philosophy and in math, the intersection of those fields and set theory and theorization lead into computer science. That's when I realized that, this is a really interesting field as well. So by the time I was doing trace law, he loved it. He was fascinated by the work I was doing. But for many years, I tried to stay away.
So you did trace law, you worked on Google Scholar, and then in 2011, you came to be the co-founder of Judicata. How did Judicata come about, and what were you trying to do with it?
So the idea with Judicata from the beginning, and we're finally at that point with Clerk where we're able to demonstrate the vision, is that law is unstructured data right now. For most people, what we read is natural text. It's unstructured, and the patterns are just not visible. If you can pull out the structure and the patterns, you can do very powerful things. And so the core idea was, well, what if we took the best of computer science, of practices around development, around the law, and marry that to workers or workforce. You can produce a very rich set of data, a very rich set of structured data, and then use that to build more advanced functionality. So search that is returning more relevant results with interface that allows you to find results that are on point faster, analytics type of functionality, and then ultimately functionality that's kind of magical, where it can help lawyers to read and write the law, for example, with reading cases and our color feature, or writing with regard to our Clerk feature. So if you have structured data, you can do all this magical stuff. But the core insight was that you need to first put a lot of investment into getting that structured data out. I guess taking a step back, one of the things I saw when I was at Google was the limits of what computers can do on their own. It was a small team. It's all software development. And because we didn't have the ability to rely on humans to do manual review, there are errors, there are sort of corner cases that are hard for the software to handle. And at Judicata, the core idea was, or one of the core ideas was, well, we need to embed humans in the mix so that they're working with the machines, working with the software to produce better data that we can then build better tools on top of.
And that, I guess, turned out to be a pretty significant development process for you. As as I've written on my blog about Judicata, I referred to it as operated in stealth mode. I mean, you started in 2011. Mm-hmm. You picked up some significant financing along the way, including from Peter Thiel, the co-founder of PayPal, and I think one of the first outside investors in Facebook. Mm-hmm. But for a long time, nobody knew what you were doing. So what were you doing all that time?
So we were doing core case parsing, language comprehension work, building data pipelines, and building infrastructures for manual review. So the comparator for us is not, say, Google Scholar, which in its own right took several years and was in stealth mode before that launched. It's Bloomberg, where you've got a very, very large company with a lot of resources to throw at the problem. We were aware of Bloomberg at the time, and we were aware of estimates of how much it cost to build. And we knew we weren't going to have that type of money to build a superior product. So we had to focus on technology that would allow us to be more efficient and reduce that cost by 90, 95, 98%.
So you mean you're talking about when Bloomberg was able to throw a whole lot of bodies at developing out Bloomberg law? Is that
exactly.
What you're talking about? Yeah.
Yes.
They had a huge budget. So they hired a ton of people.
Yep. And you can't do it with a small budget. I mean, these types of problems, getting into this space just on a development alone is many tens of millions of dollars, if not hundreds of millions of dollars, which what we raised has been quite significant, but at the same time, it's really quite small compared to what you need to compete at that highest level. So we ended up focusing on just California, and we're still California only, but building out more sophisticated software that allowed us to do better work. And what I mean by better work is we have a citator, so our version of Keysight or Shepard's that is more comprehensive and more accurate than any of the other companies. And if you look at who has citators that are comprehensive, that have red flags, orange flags, yellow flags, there are $3 billion companies out there, and then us. That's it. So that took a lot of development to do so that we could build that at a cost that was not prohibitive. It just meant that we were trading off time for money.
So is it fair to say that you were building structure for all this unstructured data?
Yes. And same goes with the search engine, where if you want to have a search engine that's actually responsive to the terms that people put in and is good at finding the relevant results, search engines differ in quality, and they differ in quality because there's different levels of sophistication of the underlying models. There's different amounts of structured data that are extracted. And so we spent a lot of effort in making sure that we had the right data and the right algorithm for identifying the most relevant results. And so the same type of thing where we were able to take a small fraction of the money and produce a search engine that returns much more relevant results than the other services. And all of that, though, was with the idea of building out functionality like Clerk, and Clerk is still not the ultimate vision. Clerk is just a stepping stone towards what if you have software that really understands the law and can help people to read and write and interact with the law. And you can't do that without structured data. That's the core. And so you need to invest in that core. It's sort of like a skyscraper. Spend a lot of time on digging a hole and putting in a foundation. But once that's in place, the building can go up pretty quickly.
All right, this is a good point to take a break, I think. I'm going to take a few moments to hear a word from our sponsor, and we'll be right back with our conversation with Itai Gurari. Stay with us. Welcome back to LawNext. I'm speaking with Itai Gurari, the co-founder of the legal research service Judicata. You were just talking about Clerk. You made a couple references to Clerk. Describe what Clerk is and what it does.
Yeah, so Clerk is a tool that will read a brief filed in California State Court, or that's to be filed in California State Court, and will evaluate the law that's being relied on, the cases that are being cited, what the type of motion is, and what the party is trying to or achieve, as well as the causes of action and the judge. It'll take all that information and compare what it sees in the brief against our structured data or our of California law and identify if there are any weaknesses or areas of improvement. So, for example, one of the things that we often see is that a brief will rely on a legal principle or make an argument and support that with case law that actually is more beneficial to the opponent. One of the things that we found with our data, judges overwhelmingly rely on cases that rule for the side that they're deciding for. So if a judge is going to grant a motion for summary judgment by the defendant, they're going to rely on cases that have previously granted a motion for summary judgment for the defendant. If they're going to deny that motion, they'll rely on cases where a plaintiff successfully argued against a motion for summary judgment. So we have a model of all these cases and what their contexts were and who won, and we can look at a brief, whether the brief is relying on point cases and cases that seem to be helpful. So that's one of many different features there, but it allows the brief to be, or I guess it allows the lawyer to pull in more data than they otherwise could and just craft better arguments that rely on stronger precedent. I
think of briefs or legal cases so often as being fact-specific or fact-dependent, and I'm wondering to what extent the information that lawyers can glean out of using Clerk really ends up being sort of dispositive in any given case.
Yeah, so that's a really good question. The law is very fact-specific, and the key thing to understand is that what Clerk is doing is not saying this case is precisely the one and only case you should rely on, or it has exactly the same facts and therefore you must rely on it. What it's saying is that these are cases that arise in the same context, the same motion, the same causes of action, potentially in front of the same judge, and are involving similar types of issues and either go your way or don't go your way. So if you're going to be relying on precedent, which you must as a lawyer, that's just the name of the game, everything is about precedent, then you want to search for your precedent within cases dealing with the same types of issues, the same causes of action, the same procedural posture, the same legal principles. Does it mean that these cases are going to be exactly the same? No, probably not. But they are going to be much more on point. And then it's the lawyer's job to decide, well, is this the case that I should be relying on? And if so, how can I analogize to it or distinguish this other case most effectively? So I'll give you an example. We ran through Clerk a brief. It was a an appeal of a judgment in it was a $50 million judgment. The Fortune 100 company was appealing that judgment. And we ran the brief through Clerk. So one of the things that we identified right away, Clerk surfaced, is that there was a directly on point case from the California Supreme Court, which had a critical argument around the use of sampling for determining class certification. It was defendant winning, which is what this corporation would want. It was after trial. It was the same causes of action, and it had the same sampling issue, and it was directly on point for that sampling issue. The brief missed that. It completely missed this directly on point case and made arguments around sampling, but missed this one that had pretty strong relevance. Now, had they seen that case and decided not to use it? Possibly. Most likely not, though. And it's just one of these things where the cases may not be perfect, but no cases. Everything within the law is about argumentation. And so the fact that there are factual differences is not a problem. It means it's an opportunity for lawyers to actually do what they do well and argue.
You've got a fascinating post up on your blog in which you analyze the briefs of some of the top law firms in the country and found that they didn't grade so well. They didn't do so well in Clerk's analysis. Is there a correlation between that grade that Clerk gave them, or the way you graded them, and the success they had ultimately in court?
Yes, there is. So Clerk evaluates briefs on about 6 dimensions, and each of those dimensions we've independently identified are correlated with winning and losing. So higher scores tend to correlate more strongly with winning, lower with doing more poorly or losing. And one of the things that we found is in grading the briefs or ranking the briefs, grading the briefs of the law firms, counting up many of them and then ranking the law firms based on that, is that the lower ranked law firms were more likely to lose in cases that they would have been expected to win, which means we looked at briefs and we have some context to identify, well, this is a long shot to begin with. Or this looks like it should be a slam dunk. The lower ranked firms were losing more of their slam dunk types of briefs. And perhaps slam dunk is a bit of an overstatement because it's very rare in the law. But these were cases that generally were favorable to them. And that was just something that we hadn't specifically evaluated or planned on evaluating, the actual winning and loss of these briefs. We were just grading them on Clerk's underlying metrics. But even with our analysis, we were able to see that the lower ranked firms were in fact losing more of the cases that they should have been winning or would have been expected to win.
We talked earlier about the human element in structuring data, I guess, and organizing data. I know you've thought a lot about the role of artificial intelligence in law generally and in legal research. What do you see as the potential for AI or the current state of AI in enhancing legal research?
A lot of potential pitfalls, so I'll be careful how I answer this. The first issue I have is one of language, that lawyers and in general the legal market and legal commentators don't really use the term artificial intelligence the way that technologists do. Generally, they mean automation and they use AI. So if you think about all the great things we hear about AI in terms of the world and the impact on gameplay, like the game Go or driverless cars or translation, none of those algorithms really have any bearing on legal research at all. The progress that's being made is real, but it's being made in legal research is real, but it's based on automation and technology and software development in general. The AI component of it is small to the point of being trivial. And so I think that a lot of
meaning that there's no reasoning involved. Is that kind of what you're saying? I mean, that it's not AI in the way that people think about it, or
so most people today, and most of the audience listening to this, probably when we say artificial intelligence, think there's some sort of learning involved, because more or less at this point in time, artificial intelligence has become synonymous with machine learning.
Right.
Was it always that way? No, but that's where it is today. And there's very little in the way of learning within legal research. There's very little in the way. It's really about structured data. It's about knowledge representation, data extraction. So it has nothing to do with really the issues of reasoning or whether it's just pattern matching. It's just that the pattern matching types of problems are not really relevant in legal research. It's a little bit tricky to explain, which is why we do it in blogs rather than in spoken word.
Yeah, but so the training that happens is training the software, as you say, to recognize patterns, not to kind of be able to extract that information into other situations or something.
Yeah. So when you're talking about legal software or legal research, you're talking about language. The core area where you have any sort of machine learning or AI component is taking the underlying words and sentences and extracting the structure from them, identifying the nouns, the verbs, how the words relate to each other, what's a subject or the object, who's doing what. That's a core level of just data modeling or extraction from the language. But the software that does that has no capacity to read or understand or say anything intelligent about that. It's just, okay, here's a sentence, this word is the noun and that word is the verb, and that's what you have. It doesn't have a model of the world, so it's unable to say, well, what is this noun and what is this verb and what do they actually mean? So it's still quite low level and basic, and the hype around AI has left many people in the legal industry with the sense that suddenly there's software running around that really is understanding the law the way humans do, and it's just, you couldn't be further from the truth. So that's what I push back against with AI, is that you have this, technologists use the term to mean certain types of problems or approaches to solving them. And the law, generally, people use AI to mean automation and to mean magical computer understanding without really knowing what that means.
Yeah. Is there anything out there now that you would point to that is that you think is an example of AI being used effectively within law?
Good question. E-discovery, due diligence, those are areas where there's a lot of potential for machine learning, for AI. I don't have deep insight into much of what they do, but they are the closest to traditional machine learning or AI types of areas within the law. A lot of what we do see in terms of legal research is more just about structured data and piecing together interesting things. So we don't promote Clerk as AI. It's as much AI as anything else, but it's pretty basic in that sense. It's more about data. I'll have to think about that, but there's nothing that really I find that compelling or exciting. And that's not to be a knock on the field. It's just that type of problem. We have different accuracy requirements. Yeah. If it didn't matter if I won a lawsuit and I had 1,000 lawsuits, and I was just kind of going in and out of lawsuits and I just going to take the statistics, sure, I would use AI to do all kinds of things because it would reduce my costs and I wouldn't care about whether I win any individual lawsuit, but I'd care about, on the whole, the multitude of lawsuits. But the law doesn't work that way. For the clients, winning or losing a litigation actually matters quite a bit. And we focus on the clients. And so we're not unique in that sense.
Yeah. I mean, it does seem that the strongest examples of what people consider AI in law, and you just mentioned e-discovery and due diligence review, are really, they're being applied against very finite and defined sets of data. And as you say, they're really just kind of recognizing patterns out of those data. They're not applying some kind of further analysis or intelligence or something against that data.
And that's sort of the story of AI across the board. And that's what's lost in the discussion. And that's why I push back. So I'm actually quite optimistic about the impact of technology in the law. I think you kind of have to be if you're going to start a tech-oriented business in this space. I just push back on the marketing messages and the way that the dialogue in the field is really nonsensical a lot of the time, with people not even realizing that it is. So I've done a lot, or I've tried very hard to educate the market so that we can have intelligent discussions about what technology can and can't do. So we can then talk about, well, how do we help clients who have certain types of problems? But I don't mean this, my sort of pushing back on AI as to sound as if I'm not very optimistic about the impact of technology. I am. It's just the language around how we talk about it is important.
Well, speaking about why you got into this, I wanted to just bring up the issue raised in essay earlier this year in the New Republic by Noam Cohen called "There's No App for Justice," in which he kind of puts out the idea that the problem maybe with the growth and development of technology in the legal profession is that it creates perhaps a bias in favor of those who have more resources and more wealth and maybe more privilege, in that they get access to the latest and greatest technology, and that others don't. And I know that you were quoted in that article. And I know that you've also written about it independently. But I just wonder how you see that from your role at Judicata. Do you feel that you're somehow serving, the wealthy, the biggest law firms, the wealthiest clients, or do you see that this is somehow driving justice more broadly?
Yeah, that's a really good question. I actually agreed with the points that were up in the article. I do think that technology often raises costs and becomes a weapon that's generally used by the wealthy. I think we see this a lot in finance, for example. And I 100% agree with the sentiments that were expressed. I differ in terms of where Judicata fits in this, and you alluded to my response in that we've actually positioned ourselves relative towards the small firms and towards the solo practitioners so that they can compete. We have entered the market with lower priced products, and we give, for example, a citator to lawyers who either don't want to be spending the money on West or Lexus for an inferior product, or can't, are priced out of the market altogether. So we've done a lot to make the law accessible to people with less in the way of means. We've had users tell us about how they were able to cite case law and family matters that were areas that typically the legal argumentation is not as strong because people don't have a lot of money. They don't have much in the way of resources. So we've been a part of helping from that side. I will say as well, the small end of the market is much more demanding than the large end of the market. So solos, small firms, they care about efficiency. They care about cost. They care about the impact of technology a lot more than the larger firms. The larger firms are really much more about messaging, I think, messaging to clients, which I do think is important. But at the same time, the end users are disjoint from the people who are paying for the products. So you end up seeing that technological change, I think, in the legal profession is going to start from the bottom and not the top. I'm not sure if I expressed that clearly, but basically, as I see it, the law may be one of these rare areas where technology development actually helps the smaller firm and the people with less resources more than the people with more resources. With more resources, you just hire more lawyers and spend more money, but you're not going to, there's no software that you're going to spend boatloads of money on that's going to really make a difference relative to having an extra 2 or 3 lawyers, which is what happens today. The large law firms just throw more bodies at the problem.
So as you mentioned earlier in the interview, you spent a lot of time developing Judicata. When I first interviewed you in 2017, you said, this is a quote, you said, "AI and machine learning only do as well as the data that goes into them. We've focused on creating better data." So you've done that, and you've been focused on California so far. Where do you go from here? What are your plans for Judicata going forward?
We have we made the decision to stay within California for the foreseeable future. For a long time, we were internally batting around the idea of whether going to New York or federal law, and we ultimately decided that the work we're going to do is going to be centered on California. We are doing work to add federal law right now. There will be some announcements around that early next year, but this is on California and taking the data we have, this high quality data, and just building more and more deeper, more intelligent, more impactful software. There are plenty of companies that are going broad where they're trying to service the whole of the country and all of the jurisdictions in the United States. And it's great that they're doing that. We don't see many companies focused on legal research from a depth first perspective, going deeper to push the limits from a technology perspective. And we've decided that that's one of the important things to us. So I'd expect to see more in California, more interesting data and more interesting ways of piecing it all together.
You said also when I interviewed you, and I'm going to put you on the spot here because you said we focused on building a search engine that returns the best results the fastest, and at this point it mops the floor with Westlaw and Lexis. I always love that quote. Do you stand by that? Do you still feel that way about your product?
Oh yeah. So we have plenty of lawyers who, even at the large law firms, have access to West or Lexis, and they use Judicata instead. So I can't remember if I told you this story, but we had a user who he worked at a nonprofit, and he had 1 hour. It was in front of an administrative law judge, some sort of employment issue. 1 hour to research an issue before going back to the judge. He found the one and only on-point case on Judicata in 10 minutes. The other side didn't find it until the hour was up. He had 50 minutes to craft an argument. That argument won. The article was written about, the case was written about in the San Francisco newspaper. That still remains true. And the reason is we have this structured data, we have this structured representation, and we have algorithms. We've focused on putting a lot of effort into making sure that our search engine is returning more relevant results. We've published data to help other companies improve the quality of their research. For us, it's really about helping the market at large. We know our competitors are using the data that we published, and we're happy about that. It improves research for everybody. But in the end, this is confirmable. Susan Nevelo-Mart did a great piece, or a great bit of research a few years ago, where she evaluated different search engines, and she was able to identify that there are differences in quality. Now, she came to a different conclusion than I did. Her conclusion was all search engines are different, and so we should use many. My conclusion is that there actually is better and there's worse, and we can all target towards producing better. And I stand by that, and I stand by the the statement that our search engine still returns more relevant results than the others. Now, everybody's making progress. So, for example, Lexis today is not where Lexis was years ago. Bloomberg today is not where Bloomberg was 2 or 3 years ago. So that's a win for for lawyers in general. But that doesn't mean there's not still a lot for them to do to catch up.
Well, and part of Susan Neville-Mart's conclusion was that the reason you should use multiple search engines is that there are biases in each of them. But are you suggesting that yours does not have biases?
No, but I think bias as a word without context is kind of dangerous. So there are very simple ways in which search algorithms can work. So the way that they worked pretty much up until 2009 when I launched Trace Law, and then Google used a different model, one similar to mine. LawNext then used this as well, and so did LexisAdvance. But prior to about 2008, 2009, legal search engines really just focused on what words were in the document and are they rare or common words, and that was about it. You need to have some more intelligent model of the world to produce better results. Is that a bias? Yes. Is it a bias that's, sexist, racist, focused on tech or something else? No, it's just, it's a bias in the sense that it has a viewpoint.
Right. We don't mean bias as a derogatory term necessarily, but simply to say, as you say, that the algorithms are written by humans, and humans bring, points of view and perspectives to the way they write them, and so they don't always they make decisions about what's important and how to weight what's important and whatever else.
Yeah, and I'd take it a step further though and say that for example, there are companies that have offered search engines in the space that they spend maybe a few weeks on building the search engine. We spent years building the search engine. That's not something that the end user sees in terms of the way the search engine looks, but they will see that in terms of the quality of the results. That's a bias towards, spending more time on the development, but that's not something that's really talked about. And that's one of the things we tried to express and why we put out the data we did about search is there is a lot of time that can be spent making more responsive results or make your search engine more responsive. And I think that the talk of bias misses the point that there's also a bias towards, do you invest a lot in your algorithm or do you not? And, nobody's really talking about that, but I think it's important to keep in mind that you can have people who spend more time and more effort on having a good quality search engine and those who spend less time. Well,
yeah. You could argue, certainly West is talking about its algorithm and investing in its algorithm, but I understand your point.
And you can also, though, take a look at the results and actually compare them as Susan has done. So yeah. I would certainly encourage anybody who wants to look into it to do that.
Yeah. I wanted to give you a chance to add any final words or anything else you wanted to mention before we wrap up.
I don't think everything else. This has been great. Thank you so much for having me on and for the opportunity to speak with you.
Well, I really appreciate it, Itai. We've been talking with Itai Gurari, the co-founder of legal research company Judicata. Big thanks, as always, to my producer, Ben Ambrogi. This is Bob Ambrogi. You've been listening to LawNext. If you like what you hear, head on over to the Apple Podcasts and leave us a positive comment. Thanks for listening.